You're paying a lot of money for your outside litigators. You're paying that money because what happens in litigation is important, and you want to make sure the work is done right. I have bad news. You're probably not getting what you're paying for, and you may not even know it. The problem is that because of the nature of modern business litigation, decision makers like you do not get the information you need to make informed decisions. And litigators have been allowed to stop valuing and stop developing the skills they need to do their jobs properly. Most lawyers, that is, no longer understand that their primary job is to be a storyteller for the client. And most lawyers don't know how to develop their client's story. So we're going to do 4 things today. We're going to identify the problems with the current state of litigation practice. Why do you as in-house counsel lack important information you need to make sound decisions? And why are litigators able to avoid developing skills that would have been taken for granted 50 or 100 years ago? Second, we're going to talk about the consequences to you and your companies of the problems we identify. Third, we're going to talk about what your outside litigator should be doing to develop your story. And finally, we're going to talk about what you can do differently to protect yourself and your company. Let's start by identifying the circumstances that I believe have led to certain problems in the legal profession. The circumstances? Civil litigators rarely try cases. Now, just about everybody knows that, but the lack of trials is pretty astounding. Between 1962 and 2012, the number of civil filings in federal court rose 5-fold, and the number of jury trials actually fell. Between September 2015 and September 2016, over 291,000 civil cases were filed in the federal courts. During that same time period, there were 1,758 jury trials nationwide. In the Central District of California, where I practice most of the time, there were over 14,000 civil case filings. There were only 78 jury trials. Now, you may not have known these specific figures, but you probably already knew that civil jury trials are a rare and dying thing. We all know that. It is possible to become a very senior litigation partner at a very prestigious firm, charging, shall we say, very prestigious rates, and never have played any role at all in a jury trial. Now, what's the practical effect of all this? Well, I want you to imagine that you're responsible for hiring a basketball coach for your organization. This is actually a pretty important position because significant money hangs in the balance. In this league, teams are awarded cash prizes for victories, and they suffer financial penalties for losses. That means the CEO cares about this basketball league. So does the board, and therefore, so do you. But there's a twist. This is an unusual basketball league in that teams very seldom play a game. They practice a lot. They occasionally show up for scheduled games and warm up. Sometimes, though it's rare, they even tip off and start the game. But almost always, at some point before the game is actually played, the teams agree to call it off. Instead of taking the risk of getting hit with the financial penalties that come with a loss, the two teams have a discussion, sometimes with the referee as a mediator, money exchanges hands, and everybody goes home. Now, this crazy basketball hypothetical is, of course, exactly the situation we have with civil litigation and litigators. We pay litigators to prepare for games that almost never happen. We all know this, but let's pause and answer our first big question. So what? Is this something you should even care about? Let me give you 3 reasons why you should. The fact is that most litigators spend all of their time churning a file in discovery, and most have very little, if any, useful trial experience, and 3 problems flow from this. First, while trials may be uncommon, they still do happen occasionally. And when they do, when you're actually going to have to play a game for once, it certainly helps to have somebody who knows what they're doing to try your case. The truth is, trying cases requires a skill set that most litigators simply do not have. Let me give just one example of this. You can be a fantastic litigator pre-trial if you're smart, hardworking, and a creative thinker. But trying cases requires some additional skills that most litigators do not have, or at least do not develop, namely charisma. If you can't keep the room's attention when you talk, trial work is probably not for you, and a very quick mental processor. You can spend time thinking about the other side's summary judgment brief. You're going to have a week or 2 weeks to respond to their arguments. A trial, you don't have that luxury. You have to make decisions instantly. You have to connect dots, including unexpected dots, instantly. You have to be able to change the anticipated script instantly. Now, one possible solution to this problem is simply to engage a trial lawyer when it appears that a particular case may actually have to be tried. And this is a good idea if you are possibly headed to trial and your current litigator doesn't know anything about trial work. But this isn't an ideal solution because a trial presentation is built during discovery. Often when a trial lawyer takes over a case that's been handled by someone else through the pretrial stages, he or she is sorely disappointed with the state of the evidence in the case. Why? Because trials are about competing stories, and stories have elements that most lawyers don't even think about during discovery. Things like setting, character development, and plot details that are not obvious to a non-storyteller. Instead, what happens is you get handed a pile of written discovery and deposition transcripts, and then you have to craft a story out of the materials there, even if they were not properly developed. This is not a good practice. Imagine if other storytellers worked this way. Do you think Steven Spielberg simply collected up lots of footage of boats and the ocean and sea life, and then at the last minute tried to craft a story from all that random footage when he made Jaws? And he was very lucky that, hey, the stuff I have here could make a great shark movie. Is that the way he would have gone about his job? It's absurd to even think about, yet that is exactly what most lawyers do. We spend a significant amount of time gathering up facts with little regard for the final product, the final story. And then we hand it to somebody shortly before trial and say, here, craft a story out of this. It's the wrong approach. Second, trials are uncommon, but truth be told, they should probably happen more frequently than they do. And often the reason they don't is because of the lawyers. Now keep in mind, you cannot control the settlement position of the other side. You can increase pressure, inside or outside of the litigation on occasion, but you cannot force the other side to be reasonable. This means if your lawyer does not know how to prepare a case for trial and does not feel comfortable ultimately trying a case, and most don't, even the really expensive ones, you're sometimes going to get forced into bad settlements. Now, I've heard lawyers brag about how they've never had to go to trial. But are we really to believe that in every single one of those cases that those lawyers have handled, the other side was reasonable in its demands? Look, no business would sign every agreement put in front of them. You have to be willing to walk away from a bad deal. Otherwise, you end up signing lots of bad deals. If you never walk away from a deal in litigation, if you always settle the case, regardless of the other side's reasonableness or lack of reasonableness, you're accepting some very bad deals. As a very junior lawyer, I asked my mentor, he was a junior partner at a very large firm, now he's a federal judge. I said, why do the lawyers in our firm never go to trial? Now that was a slight exaggeration, but very slight. And he told me, because it's too big a risk. Most of our lawyers don't have the skill sets or experience to try a case. And if you try a case and lose, you won't get paid, you might get sued, and there's a good chance you're going to ruin a client relationship for a more senior, more important partner at the firm. So when you get close to the trial date, you see a lot of arm twisting to get the client to settle the case, even if the terms being offered aren't all that great. What this means is that clients routinely get whiplash from outside litigation counsel. Counsel's gung-ho about the case at the outset, and they intend to vigorously litigate it. We're going to win this thing. Counsel remains positive throughout the bulk of discovery. But as the case gets closer to trial, outside counsel shifts 180 degrees, and now they are aggressively pushing the client to settle the case. You may have seen this happen in your own matters. If you and your litigator are not prepared to try a case, you get stuck with whatever settlement the other side is willing to stomach. It may turn out okay if the other side is reasonable, and it may not. But most litigators are not prepared to try a case. They are not willing to take on the risks of trying a case, and therefore they leave their clients at the mercy of the reasonableness or lack of reasonableness of the other side. It should not be this way. Third, litigating a case from the beginning with the goal of trial in mind will dramatically reduce costs. One of the telltale signs of a lawyer who is a pure discovery lawyer and does not have the necessary understanding of trial work is gross inefficiency in discovery. The reality is that most of what lawyers fight about in discovery just doesn't matter. Lawyers build tens or hundreds of thousands of dollars in unnecessary discovery fights and in motions to compel to get materials that will not advance a client's story. Why? The cynic in me says somebody has a minimum billable hours requirement to meet. But there's more to it than that. I don't think most lawyers will intentionally fleece their clients in that way. The bigger problem is that they simply don't know what matters and what doesn't. Most cases are going to be decided based on a handful of pieces of paper. If you know the story you want to tell and know what documents are important to that story, you can avoid unnecessary fights over trivia. And for most litigators, this inefficiency grows the closer you get to trial. Lawyers who don't have experience with or an aptitude for trial work waste more time in the months leading up to the trial date. Finally, litigating the entire case like a trial lawyer will help in all other aspects of the case. Trial lawyers are storytellers, and a trial lawyer will develop the story throughout discovery. Now, this is obviously immensely helpful if the case goes to trial, but it's also immensely helpful even if it doesn't. Winning on summary judgment, for example, is easier if the brief identifies the missing elements in the plaintiff's case in the context of a compelling story. Judges are people too, and the story is an important persuasive tool with the court. Likewise, the case will be better positioned for settlement if you have developed a consistent, compelling story that you can share with the other side or with the mediator. There are many things that drive settlement, but one of those things is a risk of losing, and a well-developed story that the other side can understand and be concerned about is a valuable tool for settlement. So, how specifically are most litigators failing? Or, put it another way, how should your litigator be building your story during discovery? Now, when we talk about this, I want to focus primarily on the deposition process, because this is where in-house counsel tend to have the most difficult time evaluating their outside litigators. Storytelling requires the development of our factual pieces. Now, this is our story during the early stages of discovery. We have a jumbled jigsaw puzzle. Reality is it's a partial jigsaw puzzle because we don't have all the pieces. Now, we may be storytellers, but we're not novelists. We can't simply make up the facts for our story. Instead, we get handed a bunch of individual facts from our client, from the documents, maybe from common sense. We have to arrange what we have. And then, and this is important, we have to find additional pieces. Neither side gets all of the pieces. Both sides get some. We have to make a picture out of those and the ones we develop in the process. Our job in deposition is to get more puzzle pieces. And that sounds obvious, but it's not, because most lawyers do a very poor job of it. So let's talk about how we do it. I want to take a relatively simple hypothetical. Let's imagine there's a dispute over control of a closely held company. And in that dispute, it's useful for both litigants to show that they are the owner who is most responsible for the company's growth and success. Now, in that case, I'm going to start with certain puzzle pieces. Probably most importantly, I'm going to have a large collection of documents from my client. Some of those documents will be good for me. Experience tells me that some of them will be bad. These are some of the starting puzzle pieces. Now, every lawyer engages in the same first step, reviewing these documents and pulling out the most useful ones to use as deposition exhibits. So let's imagine I do that, and I have an email from the other principal to my client about the company's biggest client, Acme. The email says, "Amazing job with Acme yesterday. That presentation was amazing." Now, when I teach at the National Institute of Trial Advocacy, the students I teach always want to do the same thing with a document like this. They show it to the witness. They demand that the witness agree that he wrote this email. They ask him to admit that the email statement is true. And then they immediately demand that the witness agree to their desired conclusion. So, my client Jim was responsible for landing Acme, or something like that. and the witness refuses to cooperate. They always do. So the questioner goes back again. But you said he did a great job on the Acme presentation. Yes, I said that. So obviously this presentation made the difference with Acme. No. And around they go. You see this sort of dance every day in conference rooms throughout the country. And my question is, what does a questioner get out of this? Yes, it's uncomfortable for the witness to go through that line of questioning. But so what? I recently had a case. My client had written a whole series of truly foolish emails that were not helpful a few years before the litigation started. And in deposition, opposing counsel went through each of them in the deposition. You wrote this, and you said this, and you said this. And on this goes for 20 minutes. After the deposition, the witness thought things had gone horribly wrong. I said, no, that was great. Great, he asked? I said, yes. When opposing counsel walked out of that room, he didn't have anything other than what he already had when he walked in. The emails are bad. I don't deny it. I don't like them. I wish you hadn't written them. But he had those emails yesterday. Today, that's still all that he has. His deposition was meaningless. If we walk out of that deposition and we still have only the same useful fact, the one good email, and the best we can say is that, well, I think the other side is going to look like a liar, denying all of my hard-hitting questions on this email. If that's what we have, we've failed. Because storytelling requires the development of additional factual pieces that we can use. Now, how could we do that here? We think of all the facts that are true or more likely to be true in light of the good email. And we ask very specific factual questions so we can build a fuller, more compelling narrative. So the fact that this email exists tells us what? Well, it tells us that the opposing party thought that our client did very well in the presentation. We know that. So, what was so great about the presentation? Let's get the specifics in deposition. Why was the presentation important? What about our client's presentation was good? How did the other side know it was good? Has my client given other good presentations to clients? Who? When? See, the key to a good deposition is to understand that the good facts, the good documents, the good admissions from the other side are merely starting points. And our goal must be how to figure out what the additional facts are. Which additional facts are likely true, or certainly true in light of the facts that we have. This way, we can build out a more complete, more persuasive story. So what are we not doing? We are not chasing conclusions. This is very important. First, I want to talk to you about 1950s transatlantic shipping advertisements. It was just an advertising slogan, a desperate attempt to keep the world from changing, really. In my childhood, I found it to be a terrible lie. The Cunard Line was the dominant transatlantic passenger service for much of the 20th century. You may have heard of the Lusitania, played a pretty important role in World War I, or the Queen Mary, which now sits in the harbor in Long Beach. These were Cunard ships. In the early 1950s, Cunard had a problem. The company realized that air travel was potentially going to make its services obsolete, and it needed to find a way to hold on to its customers. So it came out with a new advertising slogan, "Getting there is half the fun." Now, it's not, of course. From Odysseus to the Donner Party, history is full of examples of getting there not being much fun at all. Even so, my own mother would sometimes repeat this dishonest tagline to me as I sat in the back seat of our car on one of our lengthy road trips to see the grandparents. It was not half the fun. It wasn't in any way fun. But the journey to your destination, fun or not, is still critical. And many lawyers don't seem to understand this. They insist on spending their time chasing after conclusions. What do I mean? A conclusion is what you would conclude from a fact. It's what the fact leads the trier of fact to believe. Sally dropped the plate. Fact. Sally was reckless. Conclusion. Sally hit Bob. Fact. Sally has anger problems. Conclusion. Sally signed this agreement without reading it. Fact. Sally had no intention of performing that agreement. Conclusion. Often you can identify a conclusion because what you're trying to get is an adjective or an adverb. You might think of it as chasing characterizations. So what's the problem with chasing after conclusions? Isn't it great to get a conclusion? What if Sally admits to us that she really was reckless? That's gold. Conclusions are useful, and I do like to have them. But I see three fundamental problems with making your primary goal chasing conclusions. First, conclusions are often hard to get. The witness may not know much. The witness often knows that agreeing to your conclusion is a problem. Sometimes this is because the witness can tell your conclusion is devastating to their side. Isn't it true, Sally, that you were reckless in carrying the plate the way you did? Now, Sally may not know much, but she knows she doesn't want to agree to that. Sometimes the witness knows you're chasing a conclusion because you highlight that fact. You make clear that this is a big dramatic moment. So, what you're saying is, the witness knows better than agree to that. And conclusions, by their very nature, allow for wiggle room. You picked up the plate. It's tough to wiggle out of that. You picked up the plate carelessly. Now there's a fight. Second, if we want to get our conclusions or our characterizations, then we need to change our focus. You're likely to get much further with your witness by asking simple, factual questions that lead to your desired conclusion. Instead of demanding that Sally admit that she was reckless, ask the facts that would lead someone to that conclusion. You were carrying the plate on your head, wearing high heels, on a slip and slide, while juggling knives. If Sally says yes to those things, we've accomplished what we're trying to accomplish. The third problem with chasing after conclusions is that conclusions by themselves just aren't good enough. A conclusion is not a story. A conclusion is the moral of the story we want to tell, or maybe one of the lessons to be learned from the story we want to tell. But that's all it is. So let's say we have the conclusion we want. Sally was reckless. Maybe we had it before the deposition. Maybe Sally sent an email to a coworker that says, I was probably a little reckless with that plate. So there it is. In our document, we find that we have a fantastic conclusion. So what does that mean? Here's our cross at trial. Sally, you were reckless carrying that plate. Yes. We sit down. Or, Sally, you were reckless carrying that plate. No. So then we impeach her. Do you recognize this email? Did you write it? You sent this to your friend, didn't you? And you wrote you were a little reckless. Did I read that right? Yes. We sit down. What do we have? That's no cross. Imagine if we were to cross Sally with the questions we asked a minute ago. You were carrying the plate. You were carrying it on your head. You were wearing high heels. You were standing on a slip and slide. You were carrying it while juggling knives. Now, we don't have one star. We have an entire constellation of stars that light up the story we're trying to tell. These underlying facts will make all the difference. We've now told a story. We're not simply insisting that the jury accept our characterization. Conclusion alone is not effective. But with this collection of supporting facts, we have a solid cross-examination, frankly, regardless of whether Sally agrees with our ultimate conclusion. It no longer matters because the jury knows what the conclusion is based on the facts. The flip side of that is, if I don't have the facts, I may lose even with the conclusion that I liked so much. If Sally lays out a series of facts that would seem to support her story that she was actually very, very careful carrying the plate. Sally tells us, well, I put stickum on my hand so the plate wouldn't slide. I wore bells so that when I walked around, it would alert people I was coming so nobody would inadvertently bump into me. I had a wingman with me at all times to look for obstacles. If Sally starts to lay out a story like this to explain just how careful she was, it may not matter that she gave you this conclusion in an email, this conclusion you thought was so important. If the facts sound like she was careful, then even the admission that she was reckless may not help you ultimately. This is story development. It is what litigators should be doing, what most often they are not doing in deposition. It's just one example of how your outside litigator is probably failing you. So we talked about how the vast majority of litigators are essentially discovery lawyers and have little, if any, trial skills or experience. We've talked about some of the consequences that flow from that. We've talked in depth about one specific way in which lawyers should be doing more to develop their client's story. Now let me close with a few practical pointers to help you and your company. Obviously, because civil litigators try so few cases, it's difficult to distinguish between them. In the NBA or major college basketball, if you're trying to hire a coach, you can look at the outcomes of games to get some idea who a successful coach is. It's understandable why Phil Jackson or Mike Krzyzewski get paid good money. They've won a lot. But in our hypothetical basketball league, where teams almost never play a game, it's very difficult to distinguish between the coaches. And this is true, of course, with civil litigators. It's difficult to distinguish between them. It's a mistake to hand any substantial piece of litigation to a litigation team that cannot show you they have significant trial skills and experience. This doesn't mean that every member of the team must have significant trial skills and experience, but it does mean that at least one active member of the team needs to have it. Remember, the work of a trial lawyer starts well before trial. You cannot simply hand off the case to a trial lawyer at the last minute without having done at least some damage to your case. Second, make sure your outside litigators are developing your story. It isn't always obvious whether they are, so let me give you a few hints. You can, of course, look at the deposition transcripts and see whether the litigator is leveraging the good facts he walked in with in order to obtain other related facts that help build out a fuller, more compelling story. Or you can ask the litigator to identify the useful facts they got at deposition that they didn't already have going in the room. That means it doesn't count if they confronted the witness with a good quote in a document. They already had that quote. It doesn't help if the witness admits something that the other side has to agree to. You already had that. Instead, how did they leverage what they had walking in order to get more? If they can't answer that question, that's a very bad sign. Now here's another thing you can do. Ask your outside lawyers about the other side's witnesses. What do you know about them? How will the other side present them at trial? What have they learned about the other side's witnesses that they didn't know before taking the case? I call this taking casting seriously. Everybody knows that casting is critical in movies. Apparently, Daniel Craig is going to do only one more James Bond movie, and then they're going to have to replace him. If you read tomorrow in the paper that the new James Bond would be Danny DeVito, you would know that that franchise is probably in deep trouble. Not because DeVito's a bad actor. He's very good, and he's very experienced. But because the casting is all wrong. It's not believable. And so often lawyers want to tell a story without taking casting into account. They simply try to shoehorn the witnesses into various roles, regardless of how believable those roles are. This is always dangerous because our own client often has such a distorted view of the other side. The other side is greedy or selfish or wicked or in some other way deeply morally stunted. Our client always believes they've been wronged, and they have a perception of the other side that is flat, one-sided, and extreme. A good trial lawyer doesn't buy into this characterization. Why? Because the person the jury sees on the witness stand will be very different from your client's characterization. If you don't take casting seriously, it can ruin your case. Finally, insist on honesty from your counsel. For many lawyers, their view of the case shifts not because of new evidence, and certainly not because the law changes, but because the timing has changed. At the beginning, when the lawyer is trying to land the case and convince the client to spend money, the lawyer is excited about the case and eager to win it. Everything is positive. And this lasts until the case gets close to trial. And now the lawyer sees little about the case that's positive. All of the good aspects of the case that the lawyer once crowed about, now they're not so good. And the other side's formerly weak arguments are now, surprisingly, very, very strong. If this is what you hear from your litigator, be wary. Because lawyers who do this, and there are many of them, are telling you what you want to hear to get you to hire them and give you money. And then later, they tell you what they have to tell you in order to get you to settle the case. Why? Maybe because the case has genuinely changed. Or maybe because they're afraid of trial. Maybe they don't want to take the risk, and they'd rather have you take a bad deal. Question them closely and carefully about the reasons for their change. Compare what they say now to their earlier emails. And if you think you're being played, it's time to find a new lawyer. We've covered a lot today, and now we're out of time. There is, of course, a lot more to cover, hopefully at some future time. I want to leave you with this. Effective storytelling is hard. It's not something that happens by accident. It's something that you develop over years of very focused effort. How do you get the jury to overcome its mistrust of lawyers to listen to you? How do you help a jury get past its mistrust of big corporations so they won't assume that the company was acting from improper motives? What non-rational factors affect how judges and juries see your witnesses? And what do you have to do in your storytelling to overcome that? And of course, there are many, many other considerations like this. This is important work, and it's important that it be done well. Civil litigators don't try cases all that often. Some never do. And this affects how everybody practices. It affects how litigators work. It affects what information in-house lawyers have when they hire outside litigators. But trials still matter, and trial skills and experience matter a great deal. You have to make your determination based on incomplete evidence. Some years ago, in the third of the Indiana Jones movies, Indy walks into the room with all these potential cups. His job is to choose which one is the Holy Grail. And he's doing it based on very little information, and there are huge consequences based on his decision. His life, his father's life, lots of other things too. And what the knight tells him is what I would tell you. Choose wisely.
Thanks for watching Lawdition. Continue watching programs that will challenge your thinking, while getting to know the best lawyers in every field as they share their insights, and all while satisfying your CLE requirements. When lawyers audition for new clients, everyone wins.